All right. Good morning, everyone, and welcome back to our water fluoridation investigation. For those of you who may be joining us for the first time, we've been talking about how Henrico County is coercing us into ingesting an FDA defined drug in order to brand us like cattle on a farm. What am I talking about? Well, Henrico County is putting an FDA defined drug into the drinking water called hydrofluorosilicic acid. You can see on the label it says danger, poison, do not ingest. But Henrico County doesn't care about that. They say we're going to put it in the drinking water anyway. And what does this chemical contaminant do? What does this FDA defined drug do to you and your children? Well, it changes the structure of your teeth. So instead of having beautiful, pristine white teeth, no, forget that. They're going to change your teeth to yellow or even splotchy over here of brown, right? Yes, that is right. They are branding you and your children like cattle on a farm. So I have a major problem with this. And what I did was I filed for a declaratory judgment, a request for a permanent injunction to stop Henrico County from putting this FDA defined drug into the drinking water, and a writ of mandamus in order to compel Henrico County to provide pure water under the law. I filed this document several weeks ago, and Henrico County has until June 4th, 2026 to respond if I counted my days right, which I believe I did. That would mean that they have until tomorrow to respond to my filing. So, with all that being said, I thought I would give you guys a little taste as to what I submitted to the court. So, let's get into it, shall we? Here we go. Okay, guys, here we go. Come now, the plaintiff pro se and pursuant to the laws and Constitution of the Commonwealth of Virginia, respectfully moves this court for a declaratory judgment, permanent injunction, and writ of mandamus against the defendants, and in support thereof states as follows. This action arises from the defendant's continued addition of fluoride compounds, including hydrofluorosilicic acid, to the public water supply without clear statutory authority or local legislative authority, and without adequate public notice, purpose, justification, safety considerations, or accountability, and in a manner that implicates the plaintiff's fundamental rights to bodily integrity, health, and safety. As a Henrico County taxpayer and a direct consumer of the county's public drinking water, plaintiff is involuntarily exposed to these fluoride compounds on a daily basis. Plaintiff seeks 1. A declaratory judgment clarifying the legal authority, duties, and limitations of the defendants regarding water fluoridation. 2. A permanent injunction prohibiting any further unlawful fluoridation of the public water supply. And 3. A writ of mandamus compelling the defendants to perform their ministerial duties as required by law to provide pure water. As the court considers these actions, which seeks declaratory judgment, injunctive relief, and writ of mandamus to halt the unlawful fluoridation program and restore pure water, plaintiff respectfully requests that the court declare the following. 1. Whether Henrico County possesses the statutory authority to instruct the waterworks to add fluoride compounds such as hydrofluorosilicic acid. Under Virginia's strict Dillon rule, local governments possesses only those powers that, one, expressly granted by statute, two, necessarily or fairly implied from an express grant, or three, essential and indispensable to the exercise of an expressly granted power, and any doubt is resolved against the locality. Note, Henrico asserted via FOIA that, quote, the exact record, Virginia Code sections, that authorizes the County of Henrico to lawfully fluoridate the community drinking water are, quote, not owned or maintained by Henrico County. This is going to be located in Exhibit 3, March 30th, 2026, Request for Statutory Authority. Number 2, whether Henrico County is authorized to order the addition of hydrofluorosilicic acid to the public drinking water without an ordinance. 3, whether Henrico County is authorized to order the addition of fluoride compounds to the public drinking water without the Board of Supervisors making a policy or resolution for the fluoride program. Number 4, whether the county manager, John Vitulkis, is solely authorized to decide for himself that fluoride compounds be intentionally added to the public drinking water. In other words, can Mr. Vitulkis be the sole decision maker regarding the water fluoridation program in controversy? This is going to be located in Exhibit 92, Virginia Statutes Establishing Official Government Authority. Number 5, whether the Public Utilities Director, Bentley Chan, is solely authorized to decide for himself that fluoride compounds be intentionally added to the public drinking water. In other words, can Mr. Chan be the sole decision maker regarding the water fluoridation program in controversy? And the reference is going to be the Henrico County Ordinance, Section 23-2, Management and Records of Water and Sewer System. Number 6, who in Henrico County currently has decision-making authority to discontinue water fluoridation? If you guys have been following this water fluoridation investigation for more than a year and a half, Henrico County says that they don't know who has decision-making authority to initiate water fluoridation or to discontinue water fluoridation. The Board of Supervisor, Jody Rogish, has said at multiple meetings that he's still trying to figure out who's in charge of the water fluoridation in Henrico County. They don't know who's responsible. They don't know why the fluoride is allowed to be in the drinking water. They cannot produce any evidence that this is lawful. If you are unable, so this was an email that went out. If you are unable to figure out who has decision-making authority over community water fluoridation in Henrico, Virginia, then maybe a judge needs to figure it out for you. This email was sent on January 4th, 2025. And as you can see, I gave them ample time to figure out who's in charge of the water fluoridation program. They don't know who is responsible. They don't know who has the authority to discontinue water fluoridation. I find this to be reckless. This is going to be located in Exhibit 22, email, source of confusion, who has decision-making authority over community water fluoridation in Henrico. This is how sloppy Henrico's water fluoridation program is. They want to act like little fairies are putting the fluoride into the drinking water. They say, we don't know why we're putting it in the drinking water. We don't have any records to give you for the justification or purpose. We don't have anything for you. We don't know who's in charge. We don't know who has decision-making authority. This is an FDA-defined chemical drug that they are putting in the drinking water, and they don't know who is responsible. I find this to be egregious, which is why I have sought the help of the courts. Number 7, who in Henrico County made the decision to reintroduce fluoride compounds to the public drinking water in 2024? Did this individual or individuals have the legal authority? If you recall, first Henrico County said Virginia Department of Health was forcing them to put the fluoride in the drinking water. Well, that proved to be untrue. Then the Department of Public Utilities Director, Bentley Chan, briefly took responsibility, and he said he and he alone decided to put the fluoride in the drinking water. Then he decided to change his mind and no longer take responsibility. Then it was the county manager, John Vitulkas, that said, if it's the devil you seek, then name my name. Well, he doesn't want to publicly clarify in writing that he is the decision maker. And of course, the Board of Supervisors says that they support water fluoridation, but they don't take responsibility. So nobody wants to take responsibility for this so-called miracle drug that they're putting into the drinking water, compelling the residents of Henrico to ingest from cradle to grave. I find this to be egregious. What do you think, folks? Number 8, whether Henrico County can add the fluoride compounds back into the drinking water in 2024 without the public's knowledge or participation. Remember, they added this compound into the drinking water in secret. The public had no idea that they were adding it to the drinking water. Does that seem lawful? Does that seem responsible? Not to me. So we're going to ask the judge whether Henrico County can add the fluoride compounds back into the drinking water without the public's knowledge or participation. This is, in essence, a clandestine operation. Number 9, whether Henrico County can lawfully omit from the 2024 water quality report that fluoride compounds were intentionally being added to the water. For those of you who may be following this, if you live in another state, Henrico County calls their consumer confidence report a water quality report. And they omitted the fact that the fluoride was in the drinking water in 2024. They knew it was in the drinking water in 2024 because they were the ones intentionally adding this EPA contaminant into the drinking water, this FDA defined drug into the drinking water. So they knew good and well it was in the water, but they omitted it from the 2024 water quality report. As far as I can tell, that is a violation of the Federal Safe Drinking Water Act. So we're asking the judge to determine whether or not Henrico County can lawfully omit this fact from our water quality report. This is going to be Exhibit 2, Consumer Confidence Report for 2024. All right, number 10, whether Henrico County can add fluoride compounds to the water largely in secret. Okay, the information is not posted on any public-facing website. In order to know if the chemical contaminant is in the drinking water, you would need to do a Freedom of Information Act request to confirm this. Number 11, whether hydrofluorosilicic acid, fluoride, promotes pure water under 32.1-170 regulations. The best interpretations doctrine, the best interpretations doctrine, or best meaning approach, dictates that the courts must independently determine the most accurate objective legal meaning of a statute rather than deferring to agency interpretations. And this case that I'm citing is the Loper Bright Enterprise case. Many of you are familiar with this. So, for those of you who may be following from perhaps another state, this is going to be the Code of Virginia 32.1-170 regulations, and in it states that we are to have pure water. Pure water, as defined under the code, means that you remove the contaminations from the drinking water to make the water safe to drink. Nowhere in this state law does it say that you can add a FDA-defined chemical drug into the drinking water in order to intentionally disfigure the teeth of those in the public. Number 12, whether hydrofluorosilicic acid promotes pure water as defined under 32.1-167 definitions. Okay, so I'm asking the judge if he would be so kind as to review the definition and decide if whether or not the spirit of the law means that you put drugs in the drinking water, or if the spirit of the law is to remove contaminations from the drinking water to make it as pure as possible and safe to drink. Number 13, whether Henrico County is acting under the color of law. In response to plaintiff's FOIA request, this is Freedom of Information Act request, all documents relied upon by Henrico County in determining that the addition of fluoride to the public drinking water supply constitutes a lawful and valid exercise of police power in the interest of public health. In order for something to be a valid exercise of police power, you would have to have a state law that authorizes you to put this chemical contaminant into the drinking water. You would also have to have evidence that this in fact promotes pure health or public health. Well, it damages your thyroid, it bioaccumulates in your bones, it causes your teeth to become yellow and more brittle. So I would find it hard to believe that this chemical drug actually promotes public health. Remember, hydrofluorosilicic acid is not a nutrient, okay? So it is ridiculous to believe that something that says toxic, a danger, do not ingest, this is a poison. It's kind of hard for someone to think that a diluted poison promotes public health. Remember, during the lawsuit against the EPA, many agencies was asked what amount of fluoride is safe to ingest, and nobody could answer the question. So at this point, there is no safe level of hydrofluorosilicic acid known to exist, to ingest, okay? So there's no safe level to ingest at this point. Nobody has proven that it is safe for pregnant women and babies to ingest hydrofluorosilicic acid. Okay, so B, Letter B, defendant stated that no such record is owned or maintained by the county. So this is kind of a big deal, okay? I'm asking for the lawful and valid exercise of police power in the interest of public health. And Henrico County responds by saying that Henrico County says that there is no such record is owned or maintained by the county. In other words, they have no record to support that this is a valid exercise of police power in the interest of public health. Okay, so it's going to be very difficult for them to argue that this is a valid public health measure. 14. Whether it's reasonable or rational for Henrico County to intentionally add fluoride compounds into the water supply, into the water without documents for statutory authority, legislative authority, case law, purpose, justification, or safety. Okay, I've asked for these records and they cannot produce anything. They cannot produce a state law. They cannot produce an ordinance. They cannot produce case law. They don't have any records for the purpose. They don't have any records for the justification. They do not have any records for the safety. So that would mean that what they are doing is, in my opinion, reckless and arbitrary and capricious. It is entirely irrational and irresponsible of the County of Henrico to put an FDA-defined drug into the drinking water without any documents for safety, justification, or the purpose. That is ridiculous, in my opinion. All right, 15. Whether the Virginia Department of Health had authority to promulgate 12 VAC 5-590-930. So for those of you who may be watching in another state, this is an administrative code, so it kind of sits under the state law. So we have state law, which is going to be the Code of Virginia, and then we have what's called the Virginia Administrative Code. That's the VAC 5, Virginia Administrative Code. And these are regulations that the Virginia Department of Health writes. So they promulgate these regulations, but they can only promulgate the regulation as long as they have statutory backing. So that's how that works, folks. So we've got whether the Virginia Department of Health had authority to promulgate 12 VAC 5-590-930. And this particular regulation says the board may require owners of waterworks to provide artificial fluoridation after acknowledging that they do not have the statutory backing. And so what I'm pointing out here is the old regulation said that the board may require owners of the waterworks to provide artificial fluoridation. And from reviewing the Virginia Department of Health's meeting minutes, from my understanding of reading the meeting minutes, they acknowledge that they do not actually have the statutory backing to require owners of waterworks to provide fluoride in the drinking water. They admit that in the meeting. So I'm asking the judge if, when VDH had this language, when this language was in play, did Virginia Department of Health actually have the authority to require owners of waterworks to provide artificial fluoridation? Now, it's important to note that they use the word may instead of shall, okay? So may is very flexible in a legal sense. This is kind of a way, in my opinion, to manipulate the localities into putting the fluoride in the drinking water. They're making it appear as if they have the authority when in fact they do not, in my opinion. And so that's what we're going to have the judge figure out. Okay, this is sloppy. This is confusing for many localities. Okay, many localities said that they put the chemical contaminant into the drinking water because VDH forced them to put it in the drinking water. When I've requested for the evidence to support that claim, the localities do not have in writing that Virginia Department of Health actually required it. Okay, so apparently there's no paper trail. So it appears, based on having conversations, that the localities were tricked into putting it into the drinking water. That's the way it's coming across. Okay, so let's move on. So this is going to be located in Exhibit 19, cease and desist, unauthorized addition of fluoride to public drinking water. So this right here just shows how dysfunctional everything is, because when Henrico says, well, they required us, and VDH says, no, they wouldn't, nobody knows who's in charge. Nobody knows what they're doing. This is unacceptable, completely reckless. I mean, this is sloppy, very, very sloppy. How do you put a chemical drug in the drinking water and assume that VDH required you, right? How do you do that? How does that happen? It's because too much trust has been put into the health department. We should not trust the health department. They do not make good decisions on every single topic, okay? All right, let's move on. Number 16, whether 12 VAC 5-590-930 is void because the health department violated state law by not sending out a public notice regarding the water fluoridation regulation. This is going to be in Exhibit 19, cease and desist. Okay, so when Virginia Department of Health put in this 12 VAC 5-590-930, they were required to send out a public notice. They did not send out the proper notice, in my opinion, and that is what I have displayed in the exhibit. The public notice that they put out in the Richmond Times-Dispatch said that the regulation was regarding pure water. It never mentioned that there was going to be a regulation regarding a chemical drug being put into the drinking water, and it doesn't appear that VDH had the statutory backing to even write this regulation. So that is the controversy, folks. There's a lot going on here. All right, number 17, whether the current regulation, 12 VAC 5-590-930, the board recommends. So in 2021, they changed the language from may require to recommends. So it says the board recommends that all community waterworks in Virginia be optimally fluoridated. So I'm asking the court if this regulation has the proper statutory backing. I do not, because the state law that this regulation cites requires pure water. Pure water, as defined under the code, means that you remove contaminations from the drinking water to make it safe to drink. Nowhere in the state law does it mention that you can intentionally contaminate the drinking water with an FDA-defined chemical drug, okay? And so I'm pointing out that the statutory backing for this regulation, it would also need to be expressly granted by statute, necessarily or fairly implied from an express grant, or three, essential and indispensable to the exercise of an expressly granted power. In other words, in order for Virginia Department of Health to promulgate this regulation that says the board recommends water fluoridation, you have to have the statutory backing. That state law would have to be clear that Virginia Department of Health can recommend water fluoridation. Okay, so it needs to be expressly granted. You have to be clear about this. Number two, it would need to be necessarily or fairly implied from an express grant. So, in other words, the state law that requires pure water, does it imply that fluoride should be added to the drinking water? It does not imply. There's no law in Virginia that implies that localities should add a chemical contaminant to the drinking water and an FDA defined drug. Or is it essential? So, in other words, is hydrofluorosilicic acid essential in order to provide pure water under the law? No, hydrofluorosilicic acid is not essential in order to make the drinking water pure as defined under the code. All right, B. So this is going to be the Code of Virginia 2.2-4027, issues on review. And I'm pointing out number 2, compliance with statutory authority. That's the biggest thing that I'm pointing out. I am claiming that Henrico County does not possess the statutory authority to put hydrofluorosilicic acid into the drinking water. Number 3, observance of required procedure where any failure therein is not mere harmless. Well, we know that ingesting diluted hydrofluorosilicic acid harms the public, okay? A federal judge has ruled that this poses an unreasonable risk of injury. The FDA has banned all fluoride for children, ingestible fluoride for children under the age of 3, and children who are at low risk of tooth decay, children are at moderate risk of tooth decay. There is a litany of evidence to point out that this is harmful for children and pregnant women to ingest. There is lots of evidence, which is why 2 states have now banned water fluoridation, and they did so because they said this is public health malpractice. And just about every week there is another locality that is banning water fluoridation, and the reasons that they are giving is it is harmful to the waterworks operators and it is harmful for the public. Okay, so it's going to be kind of hard at this point to say that this is not harmless. Okay, there's just too much evidence to point to harm. So this Code of Virginia 2.2-4027 says whether the fact issues are reviewed and on the agency record or one made in the review action, the court shall take due account of the presumption of official regulatory, the experience and specialized competence of the agency, and the purpose of the basic law under which the agency has acted. So, in other words, what is the purpose of the law that requires pure water? Well, it's simple: to provide water that's safe to drink. The purpose of the pure water law isn't to intentionally contaminate the drinking water with an FDA defined drug. Okay, this is a toxic compound. Remember, on the package there's skull and crossbones. It says poison. You are putting a diluted poison into the drinking water and coercing pregnant women and children to ingest this, and a result that occurs is a type of disfigurement called dental fluorosis. They are making your teeth harder and more brittle. They are turning your teeth a different color. Does Henrico County have the authority to brand us like cattle on a farm? All right, let's move on to number 18. Whether the board can assert that water fluoridation is optional while at the same time requiring water fluoridation. Okay, this is important to point out because the regulation 12 VAC 5-5 590-930 fluoridation says the board recommends that all community waterworks in Virginia be optimally fluoridated. But then they turn around and have another regulation that says that a waterworks owner shall provide the commissioner at least 90 days prior written notice of the intent to initiate or discontinue a program to provide the optimal fluoride ion concentration. So Virginia Department of Health repeatedly says that they are not forcing the localities to put fluoride in the drinking water or keep fluoride in the drinking water. They are saying that this is just a mere recommendation. But then they wrote another regulation. This is going to be 12 VAC 5-590-510. And they are saying that you have to keep fluoride in the drinking water for 90 days. Okay? They confirm through a Freedom of Information Act request that they believe they can force Henrico County to put fluoride in the drinking water for 90 days. That if they want to discontinue water fluoridation, they need to do so 90 days prior to doing this, okay? So I do not believe that there is a state law in Virginia that authorizes Virginia Department of Health the authority to force a locality to put fluoride in the drink or keep fluoride in the drinking water for 1 day, much less 90 days. Okay. Now, I've looked at the meeting minutes for this, and they seem to indicate that the word intent is a funny thing, and that it would be difficult for Virginia Department of Health to actually force anyone to put fluoride in the drinking water for 90 days prior to their intent to discontinue. So the purpose, according to the meeting minutes, of this 90-day notice it has nothing to do with safety. The purpose is that Virginia Department of Health would like to have a heads up for when a locality is going to discontinue water fluoridation. Why? Because Virginia Department of Health wants to then contact their cronies over at Virginia Health Catalyst to go in and propagandize the city council members or the board. So in other words, Virginia Department of Health, they get a heads up, and then they call their friends over at Virginia Health Catalyst to go and lobby the Board of Supervisors to keep fluoride in the drinking water. In the meeting minutes, they said that they need to have this 90-day prior written notice in order to change hearts and minds, right? In order to change the board's decision. I find this to be utterly disgusting. So I'm asking the judge if whether or not Virginia Department of Health actually has the legal authority to write this regulation or actually require Henrico County to keep fluoride in the drinking water 90 days prior to discontinuing. How can you, on one hand, say we're just recommending it, and on the other hand, require them to keep it in the drinking water for 90 days, right? It is ridiculous, in my opinion. All right, moving on to number 19. We have whether it's rational to add fluoride compounds into the public drinking water when many of the individual VDH board members do not recommend water fluoridation. That's right, folks. I've contacted the Virginia Department of Health board members were asked in person and on the phone in 2024, 2025, 2026, why are you recommending water fluoridation? And they vehemently responded that they are not, in fact, recommending water fluoridation. For 3 years, I've contacted board members. I could not find a single board member that recommended water fluoridation. Remember, the language in this regulation says that the board recommends that all community waterworks in Virginia be optimally fluoridated. So I try to figure out which board members actually recommends this. I could not find a single board member that recommends this. They kept denying, I'm not recommending this. I'm not recommending this. I don't recommend this. They vehemently denied recommending water fluoridation. Okay, they do not want to take responsibility for this chemical drug. They do not support this chemical drug. Okay, that is the impression that I got when I had conversations with board members in 2024, 2025, and 2026. Number 20. Whether Henrico County violated 12 VAC 5-590-510 by not notifying the commissioner prior days to initiating fluoride in December of 2024. Remember, the Department of Public Utilities Director, Bentley Chan, claimed that he and he alone decided to put the fluoride back into the drinking water. Well, this 12 VAC 5-590-510 states that you have to notify the public before 90 days prior to putting it into the drinking water. And they did not. Okay, so you want to have these regulations. You want to pretend like these regulations are legitimate. Okay, let's pretend like the regulation is legitimate. Henrico County did not notify the public prior to putting the fluoride back into the drinking water in 2024. They violated this regulation. So I'm asking the judge if whether or not the county of Henrico did violate this regulation, and what is the judge going to do about it if they did. All right, so that's going to be Exhibit 1, monthly operating report, 12-month fluoride reading. Okay, so I'm providing evidence that they took it out of the drinking water and then they put it back into the drinking water in December of 2024. Number 21, whether Henrico County violated VDH's policy by not notifying the commissioner at the genesis of water fluoridation in Henrico. Now, I use the word genesis on purpose because Henrico County cannot provide me a record as to when they actually added fluoride back into, or started this fluoride program to begin with. It appears that it was in 2006, I believe, but they can't provide me a record. So did Virginia Department, or did Henrico County violate this policy that Virginia Department of Health had at that time? Remember, at first they had policies, they had endorsements, and then they switched over to making these regulations that I would argue are not lawful. So it's very complicated, guys. There's a lot going on here. So we have number 22, whether Henrico County violated 12 VAC 5-590-540 public notices, right? You have to give a public notice by not notifying the public in 2024 that defendants were adding fluoride back into the water. Maybe I misspoke on this one up here. I think I misspoke up here. I'd have to actually pull this one up. This is right. I'm providing, this one regulation says that you have to notify the commissioner 90 days prior to putting the fluoride in the drinking water. And then this regulation, 12 VAC 5-590, 540 requires that the public be notified 90 days prior as well. So Henrico County, they did not notify the commissioner before adding the fluoride in the drinking water. They did not notify the public before adding the fluoride into the drinking water. So this regulation says that at least 90 days before initiating or discontinuing a program to provide the optimal fluoride ion concentration, a waterworks owner shall deliver written notice to the waterworks consumers. A notice to consumers shall be consistent with 12 VAC 5-590-540. Section C2D. They did not notify the public. So I'm asking the judge, did they violate this regulation? Okay. All right, number 23. Whether Henrico County and VDH would have needed a law such as the proposed 1952 bill in order for their actions to be considered lawful. So if y'all checked out my cease and desist document, I showed you the proposed 1952 bill. This 1952 bill would have done two things. One, it would have authorized the cities to fluoridate the drinking water, and two, authorize the state board of health to promulgate regulations. So I'm asking the judge whether Henrico County and VDH would have needed a law such as the proposed 1952 bill in order for their decisions to be considered lawful. Do you need a state law that authorizes cities to fluoridate the water? Do you need a state law that clearly authorizes a VDH to promulgate regulations? Okay, I am arguing that you need a variety of things in order to, so here's where it's complicated. I don't believe that it's constitutional. That I think it's a violation of our Constitution to put a chemical drug into the drinking water to begin with. Okay, so let's just get that out of the way. I find this to be egregious. I don't understand how the localities have ever been able to get away with it. But nonetheless, over the last 70 years, when this goes to courts, the courts in the past has said, okay, we can put fluoride in the drinking water. But there were caveats. You would have to have a state law that authorizes it. You would have to have an ordinance that authorizes it. Henrico doesn't have either. Also, in these court records, they acknowledge that if it becomes clear that fluoride, that ingesting this chemical drug is harmful, then it's no longer lawful. You've just got to start over. And so now I would argue that the legal landscape has changed because we have so much evidence that this is harmful. We have a federal judge that says this poses an unreasonable risk of injury. We have the FDA that has banned ingestible fluoride for children under the age of 3. We have a litany of studies showing that it harms your thyroid and your bones and your enzymes and your DNA. And so the courts have said that when there is evidence to show that this is harmful, then it's a game changer. And essentially they argue that in the future they're going to rule that it is no longer lawful to put the fluoride in the drinking water. And so that is what I am contending. That is the controversy. I am saying that things have now changed, and we're not looking at the law from a case law from 1950 where they thought that fluoride was the same thing as chlorine. We've grown from here. And back then, courts ruled that it was acceptable to harm children, but the laws have changed and it's no longer acceptable to harm children. And so fluoride harms children. It causes dental fluorosis. You're disfiguring children. And I would argue that this constitutes as child abuse. So we have a lot more laws now to protect children's rights than we did in the past. In the past, the government found it acceptable to harm the public and to harm children. Laws have changed. We've grown. We're not such a barbaric society, and we no longer find it acceptable to coerce the public into ingesting a chemical drug that causes permanent disfigurement. Okay? All right, moving on. Number 24, whether fluoride poses an unreasonable risk of injury to the citizens of Henrico. So this is what I was just discussing, folks. So this case is going to be Food and Water Watch Incorporated versus United States Environmental Protection Agency. And the court said this was the finding that community water fluoridation at the level recommended by the EPA poses an unreasonable risk under the Toxic Substance Controls Act. Actually, the EPA came out in 2025 and said EPA does not recommend water fluoridation. Okay, so that has changed. I haven't found where the EPA ever recommended water fluoridation. I could understand how some people could have thought that the EPA recommended it because they were stating the reason as to why it's in the drinking water, but EPA made it crystal clear that they're not recommending water fluoridation at all whatsoever. So it appears that after the judge interpreted the EPA as recommending this, they came out and clarified, whoa, okay, we're not recommending this. See, nobody wants responsibility. The FDA refuses to regulate the fluoride that is in our public drinking water because they don't want responsibility. The EPA says we don't recommend this. They don't want the responsibility. The CDC, they recommend this, but when you ask them for the records that they've relied upon to determine that it's safe, they don't have any records to say that it's safe, and they refuse to take on the liability for when the public is harmed. So they do not take responsibility. And it's a little disheartening, I should say, that Henrico County's taken on this liability. They're, in my opinion, they're being bamboozled. They're following all these people that are recommending water fluoridation, but refuse to take on the liability. Henrico doesn't know why they're doing what they're doing. Remember, I asked for the records for the purpose, the justification, the safety. They don't have any, okay? So I would interpret that as they don't know why they're doing what they're doing. When I say, provide me the records for the purpose and justification, and they don't have any, that is extremely reckless. They're compelling children to ingest this from cradle to grave. All right, moving on. Number 25. Whether it is reasonable or rational to coerce children under the age of 3 years of age to ingest fluoride compounds through the public drinking water when the FDA banned ingestible fluoride in children under 3 years of age in 2025. Again, I'm asking the judge whether it's reasonable or rational to coerce children under the age of 3 years of age to ingest fluoride compounds through the public drinking water when the FDA banned ingestible fluoride in children under 3 years of age in 2025. And so I provided the evidence of this to the court. This is going to be U.S. Food and Drug Administration, and this was the press release. It said that the FDA acts to protect children from unapproved fluoride drug products. FDA news release October 31st, 2025. So the FDA chose to protect children from fluoride drops and fluoride tablets. But remember, the FDA doesn't regulate the sodium fluoride and hydrofluorosilicic acid in the drinking water, in the public drinking water, right? So they are not protecting children from fluoride when it's in our public drinking water. They will protect children when you have fluoride drops or fluoride tablets. And for those of you who may be new, the fluoride tablets are sodium fluoride, and for a long time that was what was used traditionally across the US, sodium fluoride. It's a powder. In recent years, they shifted over to a liquid, which is hydrofluorosilicic acid, which is just as dangerous as sodium fluoride. So what I'm driving at is the same type of fluoride that the FDA banned is the same type of fluoride that's going into your drinking water, okay? Number 26. We're asking the court whether ingesting fluoridated water promotes the health and welfare of the inhabitants. This is a word that gets used often, well, not often, it gets used in some of the statutes in Virginia. They use the word inhabitant, and when in 1952 there was a proposed bill where, and actually I'll just read through this because actually I cover this. I forgot. So this is going to be whether ingesting fluoridated water promotes the health and welfare of the inhabitants. The United States regulatory agencies don't know safe versus toxic level of fluoride. This was a deposition. Fluoride Action Network attorney Michael Conant asked United States regulatory agencies, what is the safe level of fluoride in water? When does the safe level turn into a toxic level? This is important, right? When does the safe level become toxic? Not a single one of these agencies had an answer. If you can't answer this basic question, you can't claim fluoride is safe in water. So currently at this time, there is no safe level of fluoride to ingest. There's no safe level that exists at this point, okay? There is no safe level. Similar to there's no safe level of lead to ingest, there's no safe level of mercury to ingest, there's no safe level of arsenic to ingest, there's no safe level of fluoride to ingest, okay? To put it plainly, there is no safe level known to exist to ingest. 1952 bill crossed out the line beneficial to the health of the inhabitants of such city. Okay, so when I'm asking whether ingesting fluoridated water promotes the health and welfare of the inhabitants, I do so because in the Code of Virginia it mentions inhabitants, and like I said, in the 1952 bill, they crossed out the line beneficial to the health of the inhabitants of the city. So either the legislators did not believe that ingesting a chemical drug benefits the health of the inhabitants, or the legislators had serious doubts as to whether it benefits the health of the inhabitants of the city. And Virginia Department of Health's regulation that recommends fluoride, they don't claim that it is beneficial to the health of the inhabitants. They do not claim that this promotes health. This is not a nutrient, right? Even things that are nutrients, such as vitamin C, which is an essential nutrient, we don't put that in the drinking water because it would cause a lot of problems with people, okay? There are many essential nutrients that would be idiotic if we would put into the drinking water because everybody's needs are different. So, how ridiculous is it that it's too dangerous to put essential nutrients in the drinking water, but they think it's perfectly fine to put hydrofluorosilicic acid into the drinking water? That's just utterly absurd, in my opinion. Number 27, whether it's reckless endangerment to continue to risk the public's health after the fluoride overfeed that resulted in more than a month's worth of fluoride going into the drinking water in a matter of hours. I've talked about this often. This is going to be in Exhibit 4 through 11. Okay, Eastern Henrico receives drinking water from the city of Richmond, and more than a month's worth of fluoride went into the drinking water in 5 hours and 15 minutes. So is it reckless endangerment to risk another fluoride overfeed? I would say yes. I would say that it was reckless endangerment to have the fluoride in the drinking water to begin with. I said, folks, the systems fail, okay? And that's what happened in Utah, where you had, I believe it was over 100 parts per million of fluoride went in the drinking water in Utah. They were so appalled by the fact that this could happen that they passed a law to ban fluoride in the entire state of Utah. I would argue that after this Richmond fluoride overfeed occurred, that Virginia should pass a law to ban this. This is reckless endangerment, in my opinion. And so I'm asking the judge whether it is reckless endangerment to continue to risk the public's health after the fluoride overfeed that occurred in more than a month, that resulted in more than a month's worth of fluoride going into the drinking water in a matter of hours. This was a catastrophic event, folks. It was absolutely catastrophic. There was a whistleblower that contacted the police and said, "We just poisoned everyone." Number 28, whether Henrico's clandestine water fluoridation program constitutes as child endangerment and child abuse, given that ingesting fluoride causes disfigurement. This is going to be dental fluorosis, and it poses an unreasonable risk of injury. So in Virginia, I would argue that these fluoride programs constitutes as child abuse. How could it be legal to intentionally cause disfigurement in children? It's appalling, folks. Absolutely appalling. Number 29, whether it's reasonable or rational for waterworks operators who are not doctors and county employees who don't understand the adverse health effects to use the public waterworks as a mechanism to mass medicate 2-year-olds, when, as it stands now, a doctor and a mother cannot give a child ingestible fluoride tablets and drops in a cup of water. Okay? How reasonable or rational is this that doctors and mothers are forbidden from giving 2-year-olds fluoride in a single glass of water, but the Henrico County Waterworks operators, they can give fluoride to 2-year-olds? Does that sound reasonable to you guys, folks? Does that sound rational to you? So I'm going to ask the judge, well, I did ask the judge whether or not this is reasonable or rational to do. And of course, I cited the United States Food and Drug Administration document where the FDA acts to protect children from unapproved fluoride drug products. Remember, the hydrofluorosilicic acid that is going into your drinking water, that is an FDA-defined drug. It is a unapproved FDA-defined drug, okay? Remember, the FDA, they refuse to regulate it. I find them to be derelict in their duties, but nonetheless, that is what happened because the FDA did not want to take responsibility for fluoride in the public drinking water. They said, "My name's Bennett and I ain't in it." They were smart not to get involved. Now, do I find it to be egregious that they refuse to protect the public? Yes. Do I find this to be a derelict of duties? Yes. But the FDA chose to protect their skin over protecting the public when it comes to the fluoride in the public drinking water, in my opinion, folks. This is in my opinion. Everything is my opinion based on my research. Okay, next. It's irrational that a waterworks operator is giving children fluoride while at the same time doctors are forbidden from writing fluoride prescriptions to those of the exact same age groups. Okay, this is ridiculous in my opinion. It is absolutely egregious. 30, this is going to be the last one, folks. Whether or not Henrico is required to provide pure water free from hydrofluorosilicic acid fluoride, given the relevant facts of this controversy. So guys, this was just 30 items that I have asked the county or the court to respond to declare. There are more things further down, but I thought that this was a good place to start for you guys. So you can imagine why it might be difficult for the county of Henrico to respond to this filing because there's a lot of ground to cover here, okay? A lot of ground, and several of these questions Henrico County won't be able to respond to. These are questions that have to do with whether or not Virginia Department of Health has the legal authority to recommend water fluoridation, whether Virginia Department of Health can require fluoride for 90 days prior to discontinuing, whether or not it's rational to contaminate our drinking water with an unapproved FDA defined drug, right? So they're gonna have a hard time. The only thing that they should be able to respond to is whether or not they have the statutory authority. For over a year and a half, they say they don't have any records that they've relied upon for the statutory authority. I've asked for that in the cease and desist, the statutory authority. They did not respond by citing the statutory authority. So if you don't have a state law that authorizes you to intentionally contaminate the drinking water with this chemical drug that causes disfigurement in children, it's gonna be difficult for you. So that could be why they are waiting until the stroke of midnight in order to respond to this filing. So let's go out of this, folks. All right, there we have it, folks. So that is everything. I do not believe that it is legal or rational or responsible for Henrico County to be putting a diluted poison into our drinking water, right? That's just me. I don't think that it's legal or rational for the county to be putting this chemical in the drinking water that causes permanent disfigurement in children. But what do you think? Do you think that there is a state law in Virginia that authorizes Henrico County to dilute a poison into our drinking water that causes disfigurement, that causes thyroid problems and brittle bones. I don't. But that is the controversy. That is what we are asking the judge to figure out. Remember, the waterworks operators, they don't want the responsibility. They don't claim responsibility. The DPU director, Bentley Chan, he doesn't want it. He doesn't want the responsibility. He no longer claims to be responsible for the chemical drug. And the county manager, John Vitulkas, he doesn't want to be responsible for the chemical drug in the drinking water either. Neither does any of the board of supervisors. We've got Jody Rogish. He says he believes in informed consent, and yet he is for coercing 2-year-olds to ingest diluted poison. We've got Dan Schmidt. He will laugh in your face when you say that you do not want this chemical contaminant in the drinking water. You have Misty Roundtree. She's the lawyer who refuses to have a sit down and look at the law. And we have Tyrone Nelson, who says that he believes in water fluoridation. He believes in the CDC. Who believes in the CDC? That's insane. None of these folks want to claim to be responsible for the diluted poison that is in our drinking water, which is why I felt so compelled to have to file for the declaratory judgment request for a permanent injunction to stop water fluoridation and a writ of mandamus to compel Henrico County to provide pure water under the law. Remember, these guys, they love deferring to folks like Virginia Health Catalyst, who says fluoride may be found in nature and my grass may be green in the wintertime. This is a ridiculous statement that they regularly say. We're not talking about naturally occurring calcium fluoride, folks. We are talking about hydrofluorosilicic acid. They would like for you to believe that little fairies are sprinkling natural calcium fluoride in the drinking water. Fairies are not putting this in the drinking water. Henrico County is, okay? And we're not discussing naturally occurring calcium fluoride that's safe for me to hold in my hands. No, we're talking about hydrofluorosilicic acid. Remember, this stuff has a pH of about 1.2. If I were to hold hydrofluorosilicic acid in my hands, it would eat away at all of the skin on my hands. It would eat away at the bones on my hands. I would not have a hand left. That is how dangerous this chemical contaminant really is. So, that is all I have to say about that. If you like this video, make sure to give a thumbs up, leave a comment below, and share it with somebody else. I will see you next time. Have a good one. Bye, guys.